requesting the modification, Mr. Callaway is I didn't confirm that he's 100% disabled, but he's got to be based on what he's getting. And so that would be the material and substantial change in circumstances that we're claiming, Your Honor. So requesting the modification as to support based on that. I mean, the court, you have all that before you already, Your Honor. And also the proposed order, and this is really going to be the issue. The issue is not the money. The issue is going to be the non-disclosure. We've drafted the order with non-disclosure. I believe that Ms. Callaway supports that. I believe Mr. Callaway is not in agreement. So I think that's really the issue that's before the court, Your Honor. I don't believe Ms. Callaway has any issue to the downward modification based on his becoming a disabled, 100% disabled.
All right, well, let's get some testimony on that, and then we'll get some on the circumstances, because obviously any reason for doing with non-disclosure has got to be something that's happened within the last 1 year, because we can't go back behind the original decree of divorce. So something has had to happen. And so, and the burden of proof would fall on Ms. Callaway on why that should be done. So we'll get that testimony. But for right now, let's go ahead and get all the testimony from both parties, and go try to see what we can do as far as updating the prior order. So at this time, Mr. and Ms. Callaway, both please unmute yourselves and raise your right hands. All right, do you both solemnly swear or affirm me testimony you're going to give this court today is the truth, the whole truth, and nothing but the truth to help you?
Yes, sir.
Yes, sir.
All right, you're both officially under oath, and under oath. Sorry about that. And I'll allow you to. The state's going to call you as witnesses, and you'll give your testimony. But at the end of the hearing, if either of you have anything else you think I need to know that didn't come out during the hearing because you represent yourselves, well, you're without counsel this time. I'll allow you to do so because, like I said again, you represent yourself. So long as it's relevant and pertinent, we will throw it in the mix for the purposes of making a proper decision in this matter. So at this time, I'll let the state call you both as witnesses, and we'll take it from there. Thank you.
Thank you, Ron. I'll call Mrs. Callaway. Ma'am, will you state your full name, please?
Alexandra Marie Callaway.
Okay, so let's talk about this case. You heard me tell the judge just a minute ago that the material and substantial change is that Mr. Callaway has been ruled 100% disabled. Is that your understanding?
Yes, sir.
And so, do you have any objection to the state's request to modify his support obligations downward?
No, sir.
Okay. All right. So you heard me also tell the judge a minute ago that the issue that we're really here on is going to be the non-disclosure. Is that your understanding?
Yes, sir.
All right. So let's talk about that. Do you feel safe with Mr. Callaway having your address or other contact information?
No, sir.
All right. So we're just going back to the divorce, right? We can't really go beyond the divorce. Have you been the victim of physical violence by Mr. Callaway?
Before the divorce, yes.
Okay. All right. So and again, the question is going to be what he did after the divorce, but that might serve as a backdrop. So, but I guess what I'm getting at, you have reason to fear him. Is that correct?
Yes, sir.
Because of acts that he committed before the divorce?
Yes, sir.
Okay. So let's talk about what he's done since the divorce. So no physical violence since the divorce?
No, sir.
Have there been any threats made since the divorce?
No, sir.
All right, let's talk about harassment. Have you suffered harassment from Mr. Callaway since the divorce?
He shows up unannounced at my house after I've asked him multiple times not to come here.
Ms. Callaway, it's a yes or no. I'll promise
yes.
I'll give you an opportunity
Yes.
to develop it. Okay. All right, so let's talk about that. So it sounds like you wanted to get into showing up unannounced and uninvited. How many times would you say he's done that?
Oh, there's probably been times I don't even know about, but probably a handful of times that I've noticed since there's been stuff on my front door that I've asked him to drop off at my parents' house.
Okay, so have you ever had to ask him to leave your premises?
No, he comes and goes quickly.
Okay, so how many? Again, the question is approximately how many times would you say he's? Well, let me back up a step. Do you believe that he was showing up for the purposes of harassing you?
Sometimes I feel that way. Yes.
Okay.
All right, Rob, sorry, real quick, ma'am. Where's the exchange of the children take place for visitation?
At my parents' house.
Okay, thank you. You may proceed, Mr. Diamond.
Respectfully, Your Honor, I believe the decree ordered, I think it was actually their residences was what the decree ordered, although I'd have to check that again. I believe I read that about 20 minutes ago.
Okay, all right. I had, believe it's a long decree, and I definitely hadn't had the opportunity to go through it yet. So go ahead and proceed. Thank you.
Yes, Your Honor. Yeah, the font is fine. Okay, so of the times that he showed up unannounced, what was the worst incident? Can you tell the judge about that?
Yesterday, I had my kids and I in the living room, and he swung open my screen door and then pounded on the door and then left. And we weren't expecting him to come by or anything.
So, like, how many times did you say he pounded the door?
Honestly, I couldn't tell you. I'm not sure on a number. I don't want to give you the wrong number.
Okay, and then I'm sorry, he ditched the door after you. So
Yeah,
you answered.
I know I didn't even get an opportunity to answer. He was already walking back to his car real fast.
Okay. Has he ditched the door previously?
I don't know. My door's been broken, but I don't know who did it.
Okay. Let's talk about other acts that you found harassing. Has he sent you text messages that were inappropriate?
Yes.
Okay, approximately how many inappropriate text messages would you say he sent you since the divorce?
In the last year, probably about 2 to 3. I'm not 100% sure on the number, but from just going back for the past couple months, it was at least 2 for sure.
Okay, and the word I used was inappropriate. Can you tell the court maybe in a sentence and keep it as PG as possible what inappropriate material you were sent?
So I was sent a TikTok video about having to finish and during sex. And then another one was he, I guess, saw my boyfriend here and made an inappropriate racial slur towards him, and talked about I'm getting enough, you know, penis that I shouldn't be so uptight. Things
Okay.
along that matter.
And thank you for trying not to use inappropriate language. Um, okay, so those were the text messages. Let's talk about verbal comments. Has he made inappropriate verbal comments in the divorce?
Just like little, I can't remember the exact words, but it
Well,
just makes
we'll get into
fun.
again. You're getting ahead of me. He's made inappropriate verbal comments to you. Is that correct?
Yeah, here and there.
Okay, so approximately how many inappropriate verbal comments would you say he's made since the divorce?
Well, I avoid him as much as I can, so probably that I can like somewhat remember, probably at least 5. Just
Okay.
uneasy.
Okay. Do you remember what the worst of these was? And again, try to keep it
I
court appropriate.
don't. I don't.
But these are comments about sexual
Just like
predilection.
inappropriate
Boyfriend.
stuff. Yeah.
Okay. Uh, okay. And I would offer it as background information. He was physically violent with you before the divorce. That this is part of the reason why you're afraid of him.
Yes, he has put his hands on me.
Okay. How many times did you say he put his hands on you before the
At
divorce?
least 3.
Okay.
I'm just for those of the court file, there was actually a protective order request filed in the original petition, and I'll note that also. You may proceed.
Thank you, Your Honor. Do you remember what you remember requesting a protective order, Ms. Calloway?
I think so. I don't know 100%. I'm pretty sure I did though.
Okay. The question I have, and if you don't know, you don't know, but the question is, what did Mr. Calloway do that led you to request the protective order?
Well, there was one time where he like threatened to kill me and my children, and then he ended up with supervised visits.
Okay. This was the term of the divorce, the supervised visits?
Yes, during like the whole process and stuff, we agreed upon 6 months supervised visits because my attorneys ended up hiring his attorney and almost got my case dismissed.
Okay. All right. So it sounds like temporary orders had restricted visitation. Was that ordered by the the judge who was presiding over the divorce? Was that agreed to? Do you remember what
I
what
think
happened?
so. So he agreed to the 6 months supervised visits. And then I think it was he had to maintain contact with his therapist and make sure he's taking his medications, things along those lines.
Okay. Do you recall him telling you what the diagnosis was that he needed medication for?
No.
Okay. I'll pass the witness, Your Honor.
All right, be back in just a moment, ma'am. Now we'll get Dad's side of the story. So anyway, you may call your next witness, Mr. Diamond. We'll be right back to Ms. Calloway in a moment. Thank you.
Yes, Your Honor. Mr. Calloway, will you state your full name, please?
Logan Calloway.
All right. And my understanding is you're a disabled veteran. Is that correct?
Yes, sir.
Okay.
Okay.
When were you? Yes, sir.
Yes, sir.
When were you in what's your disability rating?
100%.
When did you receive that 100% rating?
January 1st of 2020.
Okay, so okay. I guess that's not what I didn't understand that fact, so I apologize. Obviously you're making a lot less now than you were during the divorce. Did you get some sort of a recommendation from a doctor that you needed to cease working, or why has there been such a change in the income?
I was a teacher and I had to resign.
Okay.
Were you, sir, did you work for a private institution or were you hired by an ISD?
ISD, sir.
Which one, please?
Copper's Cove ISD,
Okay.
middle school.
All right. And when did you leave working there?
About February of last year.
All right. Right before the divorce was granted?
Yes, sir.
All right. Thank you. You may proceed, Mr. Diamond.
All right. And again, I'm not trying to drag you through the mud here, Mr. Calloway, at least, especially not as far as the employment goes. My understanding is that you lost the position. Is that correct?
Yes, sir.
Okay. And it's your belief that you're probably not going to have another opportunity to teach. Is that correct?
Probably not at that school particularly, but I'm trying to go get. So sorry, short answer. Not at that school, but I can go teach at another school.
Okay.
All right. So were you
I guess
suspended or were you fired or what was the actual term that there was used for your departure from the CCISD, please?
You could, well, I can't say fired, but pretty much like it was either put in the what's it called again? The red letter of resignation, or they're gonna have to let me go. I said okay.
Okay. And that was in February of last year.
Yes, sir.
All right. And you've not sought employment as a teacher anywhere since then, sir?
No, sir. No, I haven't.
Okay. All right, thank you. You may proceed with the question, Mr. Diamond.
I mean, again, I'm trying to work with you at least here on the money, Mr. Calloway, because I think that this money is appropriate. So help me out here. I mean, let's just be realistic. Something happened and it's going to make it hard for you to find a job teaching anytime in the near future. Agree or disagree?
You could say agree, sir. I'm currently working on getting a certificate. I was under what was it called? Sorry. It was year by year, and I was just about to get that certificate, and situation happened, and all of a sudden I had to resign. So I applied to other places, teaching, subbing, security, and I had no luck. So.
And like I said, this all took place last year, correct, sir?
Yes, sir.
Okay.
I mean, again,
Okay, so this took place in February. You were divorced in March, but yet do you know why that were you working? I'm sorry, you weren't working at the time of divorce for the ISD, correct?
I was working up until that February. I was working for the ISD.
All right, so you were actually still working for them at the time of the divorce.
Yes, sir. Until February, sir. Yes, sir.
Well, the divorce wasn't granted until March.
it was signed March 8th, Your Honor, 2024.
Right. Okay, let me see what the proof update was. Okay. Okay. Okay, so the court heard the case on March 8th also. So, all right, it's heard and signed off on the same day. All right, you may proceed with the witness, Mr. Diamond.
All right. So based on your testimony, I don't even know that this modification is going to get granted, Mr. Callaway. But I take it you're opposed to Miss Callaway's address not being disclosed. Is that correct? You want to have that information?
Yes, sir.
Okay. And I think that the starting point is going to be that that's reasonable. So, have you been convicted of any crimes or misdemeanor involving family violence in the last 2 years?
No.
Have any protective orders been issued against you in the last 2 years?
No.
Are there any charges pending that the court ought to know about?
No.
All right. What about these 2 or 3 text messages that Miss Callaway mentioned? What was going on there?
I don't even remember those, if I'm gonna be honest with you, sir. I have to go back to see what exactly it was, but I don't know what exactly she's talking about. I remember her saying that, but I don't know what the reason was for.
Okay. She's saying there's one text message about her performance and another text message about her boyfriend's ethnicity. That neither one of those rings a bell.
Yes. Now, for
Which
what
one rings a
reason?
bell?
So, well, for what reason? I don't remember what exactly the reason was. Like, so the first time, like I said, even like first she said stopping at the house is to drop off clothes. Right. So
Okay.
it was a drop off clothes, and that was it. I left because there's no need to talk, no need for her to feel a certain way. I dropped off the clothes, knocked on the door, and left.
Okay.
And the same thing with what's it called? It was the medical cards, because she told the CSO she's been asking for them. I was like, okay, and I asked her twice in message, hey, when can we meet? And she hasn't given me a hey, can we meet at my parents' house or nothing. So I didn't want any reason, for the court to say I didn't give it to her. So I put in an envelope, put it like in a slot in her door, knocked on the door, and I walked. I didn't bang on the door. I knocked on the door and I walked away. There was like,
Okay.
there's no harm, there's no nothing. I just knocked on the door to let her know, hey, they're there, and I walked away.
Okay. And she said there were 5 to 10 comments about her having sufficient. I'm trying to be appropriate here.
Let's not
Partners.
go down that path. Let's not go down that path.
Yes, Your Honor.
But okay,
I'll pass
it
away.
was the comments were sexual in nature, sir. Do you recall any such comments?
Yes, sir.
Okay. And that's post divorce, sir, correct?
Yes, sir.
All right, thank you. You may proceed, Mr. Diamond.
I'll pass the witness, Your Honor.
All right, guys. Sir, this is the end of the school year. Obviously, that's problematic in and of itself. Do you anticipate actually trying to go back to work for an ISD sometime starting in the fall of 2025, sir.
That is the goal, yes, sir.
Okay. All right, thank you. All right, guys. Are y'all on app close already?
Yes, sir.
Okay. All right, thank you. All right, any questions of either witness at this time, Mr. Diamond? We're looking at a temp order, sir.
I understand, Your Honor. I don't know that I have questions that are going to get the court what it would need to make a final ruling.
All right, then. All right, folks. The information is, yes, one thing, but the problem I'm really having is I was under the impression that the disability, 100% disability came down the pike since the divorce. And no, that was actually before the divorce. So that was always a factor. But the factor was, sir, you know, the military will declare you 100% disabled. But that's not like Social Security where you actually you can't go to work the next day. You still can go work at a full-time job. And obviously that's what you were doing for a time certain until you were discharged from Copper's Cove ISD. And you say it's your plan to try to get back this fall. So again, I'm looking at probably going ahead and making a temporary order, changing the child support downward until we come back for a final order and get an update on your job circumstances, sir, or job search circumstances. Because right now, it sounds like if you could be a teacher, you could work somewhere at least making minimum wage. So I'm supposed to order at least a minimum wage presumption on top of your social on your VA disability. But I'm not going to go ahead and go down that road right now. I want to go ahead and see if you do get a full-time job where we could actually get the real amount you're going to be making and do the real math going forward. For right now, I'm looking at going ahead and making a temporary order. I'm looking at changing the temporary child support. I am looking at going ahead and ordering a temporary non-disclosure, but you already know where she lives. So, ma'am, if you move during the time frame before we come back, then obviously you don't have to let him know. But at final hearing, I may have to change that around. But for right now, it is what it is. I'm going to, I want to, at this time, just to be on the super safe side, because again, sir, the comments were totally inappropriate. Okay, you can't do that. You're not, you know, she's not your wife, and what you do in your life is not her business, and what she does and what she does in hers is not your business, so long as it's not revolving around the kids. So I'm looking at going ahead and making a temporary order. Like I said, I'm going to go ahead and appoint what's called an attorney ad litem for the children to make sure that these kids are not being infected in any manner, way, shape, or form that's inappropriate. So I'm giving the kids a lawyer, but the lawyer will do the investigation. I don't want to go into any details, sir, why you may have been let go by Copper's Cove ISD, but this ad litem is going to investigate all that and come back with recommendations that he or she feels are in their client's best interest going forward. And we'll try to figure that out, what we're going to end up doing in the long run here. But for right now, I noticed the state, it was a CSRO, so the state did not file a copy of the standing order that's on brand new cause of action. It should, I didn't see it in your divorce petition, but it should have been. But there's a standing order of how parties are to behave while this case is pending, SAPSR cases are pending. And I'm going to have the state attach that to the temporary order in this matter. So you both are technically restrained based on that. That is the order that's been signed by all the district judges, including the presiding judge of the 426, which is your district court. So that's what they all say we have to do, or you have to do, and you have to abide by it. So a copy of it will be attached on the temporary order. I'm going to go ahead and change the child support down. I'm not modifying anything else as far as the access visitation. That the decree will still control, but I'm going to go ahead and I'm going to appoint. Let's see who's up next, Mr. Gustafson or Mr. Bramhall. I know it's one of the two. All right, let's go with Ms. Gustafson. I'm going to appoint, okay, sorry, I lost my Excel. Here it is. Spreadsheet. I'm going to appoint Ms. Janet Gustafson as the attorney, what's called the attorney/guardian ad litem for your kids. She'll make recommendations going forward on your, and she doesn't have to worry about custody, or the other things, but she does have the right to question and get information about child support because that affects them. And she does have the right to make recommendations and complete any and all investigations concerning any inappropriate behavior by either party. So both of you will get a chance to talk to her. She's going to interview both of you. She's going to get the 411 on everything that y'all have at this point. But again, folks, y'all been divorced for a year. You're not husband and wife, and the court doesn't appreciate inappropriate behavior because it just makes my day longer. Okay, and it's already long enough. So again, that's what we're going to do. Ms. Gustafson's going to be in contact with both of you. We probably won't get this thing done for a final hearing until we know what Mr. Callaway is going to be doing this coming fall. But if he's not employed by sometime in August, and I'm probably looking at an August date for a reset on this one. If he's not employed by sometime in August. Okay. I think that's my. Okay, did that turn on the YouTube pop up on me? Okay, maybe I'm just getting feedback. Okay. But anyway, I'm gonna go ahead and let me look at the Zoom calendar for August. I was just in July, so that should still be around. Let's see.
Your Honor, Ms. Walker just messaged me some dates with Ms. Gustafson's on the calendar, although they're May and June.
Okay. So I'll tell you, I'll tell you what, we're gonna do a pre-trial in June. And we may can end this by then, but I'm gonna go. What dates do you have Ms. Gustafson already here?
The 10th, Your Honor.
The 10th?
Yes, sir.
I'm gonna go ahead and reset this matter for a pretrial on the 10th, and that way Ms. Gustafson does have a couple of months to do a preliminary. And if she needs to file any pleadings in her client's behalf, she'll do so and get you served and get you noticed and get all the I's dotted and all the T's crossed in conformity with the Texas Rules of Civil Procedure. But a pretrial is just a quick hearing to tell to see how things are going, and by then we might even have an update on what Mr. Callaway is going to be doing this coming fall. But again, it's just to get something set up, and I'm probably looking at setting this up as a either a private Zoom for a final. That way you don't have to wait around all day. You get your own time slot, and we'll get that taken care of. Or we may set it up as a final hearing before the court. It just depends on what the ad litem thinks how she wants to try to handle this, but it's more likely going to be just a Zoom, and nobody has to come down to the courthouse unless I find out a lot of things that I think are inappropriate to go out over the web unfiltered. So I can filter them in the courtroom a lot easier than I can filter them on Zoom. So at this time, I'm going to go ahead and start with you, ma'am. Anything else you think I need to know? Well, I'll start. Any questions, and then anything else you think I need to know, and then, sir, I'm going to come back to you for that same questions, okay? Or for those same questions. So, Ms. Callaway, anything else, any questions this time, ma'am? Anything else you think I need to know?
No, sir. I just want him to stop coming to my house unannounced.
Yes, ma'am. Well, again, the standing order kind of addresses that also. And here's the deal, sir. The standing order, and ma'am, the standing order would say violation of the standing order is something that can be, you can be held in contempt. And that 180-day sentence I talked about at the first of the court docket this morning, yeah, that comes into play because it's technically a restraining order, okay? It's called a standing order, but it's a restraining order. So y'all have to abide by that order. Otherwise, again, the ad litem would have the perfect right. Like I say, the ad litem doesn't represent you, sir, doesn't represent mom. But for the protection of her clients, she can file her own motions for contempt. So again, just follow the order and do everything and don't do anything in violation of the order. Anything else, ma'am?
Yes, sir.
All right. Now, Mr. Callaway, question, sir.
None at this time, sir.
All right, sir. And again, you get to talk to the ad litem, and you get to tell her things that you want to come out. So you can do that also. I'm going to need both your permissions to have the state give her your email addresses and your phone numbers so she can contact you. Do I have that? Do I have your permission, Mr. Callaway?
Yes, sir.
All right, Ms. Callaway.
Yes, sir.
All right, thank you very much. All right, Mr. Diamond, again, let's go ahead and do the temporary child support. We'll do the mod. I'll go ahead and grant temporary non-disclosure, but I'm going to go ahead and put in full enforcement effect of the standing order, and of course, anything dealing with visitation and anything else that's covered by the decree of divorce is still in full in full effect. And if the ad litem needs to tweak that with a motion, she can do it, and we'll figure that out. But for right now, we're just gonna leave everything else as is. Anything else, Mr. Diamond?
Yes, Your Honor. I apologize for not having a better handle on the facts of this case.
Well,
That's all I have,
bit.
but I'll get this out as soon as I can.
All right. Again, folks, thank you very much. And we'll go ahead and get y'all taken care of. And again, like the lawyer's name is Jonica Stopson, and she will give her, lawyers are kind of busy sometimes, especially toward the end of school year. So give her a couple of weeks at least to get in contact with you. And if she doesn't by then, her information will be in the reset order. Y'all can always drop her a line or send her an email and see and ask, hey, I'm you're representing my kids, and I was just contacting you to get in to see about where how you want to set that up. Okay.
Yes, sir.
All right, guys. Anyway, I'll let the state prepare that order, and we'll see you both in June on the pretrial, and we're off the record. Thank you.
It's the state's understanding that both Mr. Montalvo Correa and Ms. Chambliss are in agreement to do a second further temporary order. This would change the prior order so that the mother is responsible for maintaining government medical for the child. Apparently, Your Honor, it is not as cost-friendly as previously for it to be through her employer, and the child does actually have coverage through a government source. Mr. Montalvo Correa's cash medical, would change to $28 per month, which would make his child support $198 per month. And both of these amounts would start on May 1st of 2025. Your Honor, it's the state's understanding parties will testify to the current circumstances, which is why we're doing a downward modification, specifically Mr. Montalvo's recent car accident that resulted in the totaling of his car and him undergoing some physical therapy and other things at this time. So the mother is willing to agree to the minimum wage since there is nothing saying he cannot work, period. And so we'd like to revisit that in July, hopefully after the 8th of that month. So he has a full 3-month period to complete whatever is required of him, physical and mental therapy wise. And then we can get an update on documents requested by the state, such as 23, 24, 1099s, and tax returns, because retroactive support is being sought in this case back to June of 2022. And additionally, Your Honor, there may be some direct payments during that period. So we're also looking at Cash App transactions, which may not be available. Excuse me.
All right, then. Thank you. Let's get some testimony and confirm that this is what we're going to do for now, and confirm the reset date through the testimony also. So at this time, I'll ask both parties to please turn on their videos and raise their right hands, please. Thank you. All right, do you both solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and nothing but the truth so help you?
I do.
You muted, sir. I'm sorry. You gotta mute yourself.
Yes, Your Honor.
All right. All right. You're both officially under oath, and you can put your hands down, and I'll let the state call you as witnesses. If there's anything at the end of the hearing either you think want to testify to that didn't come out in your general testimony, you'll be allowed to do that so long as it's relevant. But at this time, I'll go ahead and let Ms. Bongat call you as witnesses, and we'll take it from there. Thank you.
Thanks, Your Honor. The state calls Ms. Chambliss. Ma'am, what is your full name?
Crystal Monique Chambliss.
And ma'am, who is the child in this case?
Christian Scott Correa.
And is Christian your son,
Yes.
as well as Mr. Jonathan Montalvo Correa?
Yes.
Yes.
Were you able to hear my opening statement to the court, ma'am?
Yes.
Was that most of what you understood the three of us to be asking for today?
Yes.
So specifically, since we did the further temporary order, is it correct that the insurance available through your employer is no longer a reasonable cost?
Yes.
But at this time, there is outside or other coverage available for your son?
Yes, ma'am.
And for that reason, ma'am, you were in agreement with us changing the order to reflect still you as the person providing it, but no longer your employer.
Yes, ma'am.
And then as far as changing the support at this time, were you aware of Mr. Montalvo Correa's health and work circumstances?
Yes, as of recently.
And so, ma'am, for the months of May, June, and July, since we'll be coming in after the first of that month, you're in agreement for Mr. Montalvo Correa to pay based on the minimum wage presumption
Yes, ma'am.
and him having one other minor child in his home.
Yes, ma'am.
And so that would make his cash medical amount $28 per month, with child support being $198 per month.
Yes, ma'am.
And then as far as the information the state is looking for, you are in agreement that retroactive support is being sought in this case?
Yes.
And you have no problem with the state requesting that Mr. Montalvo Correa provide income information such as 1099s, tax returns, or whatever is available since June of 2022?
Yes, I'm aware of that.
And then, ma'am, as far as any direct payments between the two of you for the support of your son, to include daycare fees, etc., you and he are also in agreement to look for Cash App or other records that might point to what was actually exchanged?
Yes, ma'am.
And then, ma'am, as far as the first amended petition, I believe you were given a copy through e-filing because you were here to request the non-disclosure. Is that accurate?
Yes, ma'am.
And so as far as these second further temporary orders, is it also correct that you and the father are in agreement to not disclose information at this time based on the two of you making arrangements through app close?
Yes, ma'am.
And you understand, ma'am, that the court will revisit this issue at final to see if it's appropriate for the two of you not to disclose the information in the court order or update each other in the future?
Yes, ma'am.
Excuse me, ma'am. Was there anything else you wanted the court to consider at this time?
Not at this time.
And as far as our return date to court, Ms. Chambliss, were there any dates we needed to watch out for after July 8th if we were giving Mr. Montalvo Correa the full 3 months?
No, ma'am.
Thank you, ma'am. Your Honor, I pass this witness.
All right, call your next witness, please. I'll be back to you in just a moment, ma'am. Thank you.
The state calls Mr. Montalvo Correa. Sir, what is your full name?
Jonathan Montalvo Correa.
And sir, is it correct that you are the father of Christian?
Correct.
Were you able to hear my opening statement to the court, sir?
Yes, ma'am.
Was that an accurate description of the relief you're joining Ms. Chambliss and the state and asking for approval from the court?
Yes, ma'am.
So specifically, sir, we're wanting to change how your son has health coverage and the child and medical support you pay based on the circumstances that have been described.
Yes, ma'am.
And so, sir, you have no problem with the court ordering the changes in your support amounts to $28 and $198 beginning May 1st?
Yes, ma'am.
Sorry, sir. You're fine with that?
Yes, ma'am.
All right. And you understand, sir, that at final hearing, which will hopefully be in July, we'll address the issue of retroactive or back child support going back to June of 2022?
Yes, ma'am.
And in the meantime, you understand that the state's requesting additional information from each of you, specifically income information such as 1099s, W-2s, income taxes since that time, and then any Cash App records the two of you may have if there were any direct payments.
Yes, ma'am.
And was there anything else, sir, you wanted the court to consider?
No, ma'am.
And sir, as far as my last question to Ms. Chambliss, you were served with our amended pleading and the request for not determining whether addresses and contact information should be disclosed, correct?
Correct.
And so as far as in the interim, sir, you're fine with neither of your information appearing, with the court being able to revisit that issue at the final hearing to see if it's appropriate going forward?
Yes, ma'am.
And as far as the previously ordered use of app close, would you say that has been working, sir, and should continue in the meantime?
Yes, ma'am.
Thank you, sir. Your Honor, I pass this witness.
All right, folks, I'm looking at granting everything you're requesting. Obviously, this is a temp, so we can fix anything at final hearing that didn't get done properly here, but right now, everything sounds appropriate. The only thing I do need to let you warn you about, sir, the state's asking you for certain discovery, and if that information is not provided at the final hearing, you may not be able to testify to anything that would have been in that information because you did not provide that as part of your discovery. And that's one of the rules of law. If you don't provide the information, you can't tell your side of the story about it, okay? Because there's no way to verify that. So please provide that, and that way we can figure out what everything's going to be going forward. But at this point, I'm going to start with you, sir. Is there anything else that you think you need to tell the court, or anything you're specifically asking for that didn't get addressed, sir?
No, Your Honor.
All right. How about you, ma'am?
No, Your Honor.
All right, then, Ms. Bongat, I'll go ahead and grant that order as a temp and reset. And what was the reset date again, please?
Your Honor, we don't have any July dates that are Zoom except for July 1, and I wasn't sure if July 8th was going to be one.
Yeah, well, I finally got y'all. Yeah, I'll sorry. I'll go ahead and set those up. You can go ahead and put down July 8th. I'll go ahead and make that right now and send that over to Ms. Walker. And because yeah, I understand y'all are doing your mag thing or swag thing at the last week of July. Is that correct?
Yes, Your Honor.
All right, then. All right, let me go ahead. I'll go ahead and set that up right now and get that over to y'all. And you can go ahead and put that down as a date, and you'll have the Zoom code in just a moment. Thank you.
Thank you, Your Honor. Ma'am and sir, I'm going to put you back in your breakout rooms.